Any mention?
Question may be to item number 33 and 35.
Item?
Yes.
Item?
Item 33.
Nurul Islam. Why keep on adjourning this matter?
I was not in a position to contact to him, and it was required to
It
have
was
some
not
contact to
required for
him.
what?
To contact the petitioner.
Then it's not interested to dismiss it. Next date, 1 week, yes.
2 weeks, Your Lordship.
1 week. Telling which will dismiss it. You've avoided to take up this matter now consistently for many, many dates. Yes.
Obliged.
You're not interested. Why should you be bothered? Yes.
Then just what 35.
35. Who's the other side?
I'm for the respondent, Your Lordship.
Who's the other side? You're for the respondent.
I'm for the respondent.
Who's the petitioner?
K.C. Gautam, I didn't see.
Where's C.C. Gautam? You have to inform them at least, Mr. Devna. 35. Yes, inform them, then we'll adjourn it. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 34, Your Lordship.
Other side's whom?
After 2 weeks, Your Lordship.
No
No
objection, Your
objection.
Lordship.
Yeah, 2 weeks, yes.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 32, Your Lordship. Let this matter meeting after 2 weeks.
2 weeks, okay.
Thank you, Your Lordship.
May I please, Your Lordship, I beg to mention item number 30.
Sikandar Ali,
Yes, Lordship.
you're for whom?
For the respondent number 3, Your Lordship.
Where's the petitioner?
Appearing through this.
You have no objection?
No, Your Lordship.
How long? 1 week?
2 weeks, Your Lordship.
Okay, yes.
Obliged, Your Lordship.
Yes, MS Salam.
Your Lordship, I beg to mention item 28, Your Lordship.
Other side?
I'll inform the respondent.
You inform them?
I will inform them, Your Lordship.
Your Lordship, no objection.
I'm praying for
1
2
week.
weeks' time, Your Lordship. 2 weeks, Your Lordship.
Why?
Some personal difficulty.
This matter's already heard substantially, I think, yes. Yes.
Obliged, Your Lordship.
Obliged, Your Lordship.
Yes, please, Lordship. Lordship, I beg to mention item 27, Lordship.
27.
27, Lordship. Lordship, I'm praying for 2 weeks' time, Lordship, for this matter.
No objection.
Why?
Just some
Today,
difficulties.
I see the time.
First-
This matter will take long time also, the further appeals.
Lordship, similar prayer for item number 37, Lordship.
You other side?
Yes,
So I've
No
informed,
objection.
Lordship.
2 weeks, okay.
Deeply obliged, Lordship.
thank you, Lordship.
Daily list item number 1.
May I please, Your Lordship? My Lord, I am an assistant teacher at Jawaharlal Nehru Higher Secondary School, Fulbari, my Lord, in the West Garo Hills district, my Lord. I have not been paid my salary for the past 1 year and 10 months, my Lord. Now, my
1 year, 10
appointment,
months, why?
my Lord, my appointment, my Lord, with other appointment were challenged before this honorable court, my
By
Lord.
whom? Number what?
By the unsuccessful candidates, my Lord. But by the unsuccessful candidates. But there is no stay order, my Lord. And also, my Lord has passed this order, that is order dated 5th of September 2023, my Lord. And in this order, my Lord has said, may I just read, my Lord?
Yes.
Mr. P. Yobin, learned counsel for the respondent number 8, and Miss so-and-so, learned counsel for respondent number 9 and 10, submit. They are the teachers who have been appointed since August 2022. And there is no stay orders operating against them. But however, they have not been paid any salary till date. It is made clear that if they are entitled, pendency of this writ petition shall not stand in the way for respondent managing committee paying the salaries of the respondents, my Lord. So this was the order passed, my Lord. Now, my Lord, on
Why
the
you
basis,
filed on the same cause of action?
I'm sorry, my Lord.
Have you filed a second writ petition on the same cause of action?
My Lord, here why I had to come and file this writ petition, my Lord,
Why?
separately, my Lord, is because, my Lord, the managing committee, my lord, is not in writing, but whenever I go and ask for the salary, they're saying that no, this order is not specific.
No, but why didn't you file application, the pending writ petition? Why fresh one?
In that
Where's
petition.
the order? Let's see, is in WPC number?
This is in WPC number
425.
425, my lord, page 13, my lord, page 13. Now, they are not taking the consideration of these directions at all, my
So
lord.
why, what's the stage of this case, 425/2022?
That stage is for hearing, my lord.
Then?
That stage
Why
is
the
for,
first thing for hearing then?
my lord, that stage is for hearing. We have filed all the affidavits and it's fixed for hearing, my lord. But, my lord, that is a separate issue. The thing is that now, my lord, there is no stay order. Therefore, we have been allowed to teach from the day I was appointed,
What
August.
this court wants to know is,
Yes.
is there a new cause of action that has caused you to come before this court by fresh writ petition?
Oh,
Or the issue that you're canvassing now is already there in the earlier petition?
No,
that's
no,
425?
it was not there in the
It's not
other.
there?
No,
Okay.
salary, regarding salary, nothing
Yes,
is
Mr.
there, my
Harmi.
lord.
Why not paying salary? And the order is there from 5/9/23.
I'll obtain the instructions. Let the notice
Are
also
you
be-
appearing in the other case?
No, no, I'm not appearing in the other case.
Heard Mr. Piyobin issue notice. Mr. Kharmi. H. Kharmi. So accepted on the behalf of
Respondent number 1, 2, and 3.
respondents number 1, 2, and 3. Notice to go respondent number 4 is at 83 days. Just after 3 weeks is
My lord, obliged.
together with 4 to 5.
My lord. I'm sorry?
Let notice
le-
go first.
Let, my lord, obliged.
Item number 2.
May I please, Your Lordship, that is regarding the managing committee illegally constituted without notice, without serving any, holding this general public meeting
Terms from when to when?
from 2099 continuously for their family members only.
No, from when? The term is from when to when?
Now,
Which term is
it
challenging?
is already over, my lord, that we received the caveat, then only we come to know that managing committee is already constituted. Before that, we have submitted 2 representation in anticipation to make an expert inquiry.
No,
And the
understand.
managing,
What do you mean? Where's the resolution? Where's the impugned constitution? Where is it?
it is not here, my lord.
You
You know,
impugned.
only this caveat we came to know. They have filed a caveat, my lord. Then only we came to know that they have already constituted a managing committee of 38 August 2023, my lord.
What caveat?
Caveat is page number
Against you?
13. Yes, my lord, 29. Then
You
only
mean
we
this,
come
sir?
to know. Before
You
that,
are?
we have no idea.
Who's the petitioner here?
Here, this one Siddiq Hossain, my lord. He is
Well,
one
you're
of
not the prospective petitioner on the caveat.
No, because they have sent a caveat to other members. He is one of the complainant in this case, my lord. Because we have submitted 2 representation. Because after the date, one late Abu Bakr Siddiq, my lord, he was continuously president and secretary of the managing committee, 99. After that, we thought they will make the managing committee. So one we have filed, and
Now,
second,
why you don't have the copy of the resolution?
because
What are you challenging? This on what will we go on?
no, because a caveat they have mentioned this number and all, my lord. Because we are trying, but we are not getting, my lord. And due course, we will submit it, my lord.
Challenging the order date 38/22.
Yeah, 23, my lord.
Is here in caveat at paragraph 422.
No, no, my lord. This is wrong, my lord.
See page 35, paragraph 4.
It is in the prayer, my lord.
Also, okay.
In the prayer.
Yes. Now you here they've annexed the copy of the order. You don't have the copy, but
No, no, my lord.
then how do you get the caveat order getting the annexure?
No, because we caveat through that, we have applied for that. It will take time, my lord. So
How do you get this caveat petition? Who gave it to you?
that
If you're not the prospective petitioner named in the caveat, who gave this caveat petition to you? How does it serve to you?
no, one of the caveat holder they have served me because of
Then
the
they serve
villager.
you- Where's the? Then they said annexed here to the caveat the order you seek to impugn.
Yes, yes. One is Abdul Qayyum and another is.
No. See para 3. of the caveat. Read it, Mrs. Hazarika.
Yes. 1, 2. Oh. That the caveat or state that the office of the Registrar has approved the regular committee of Maulakandi Secondary Certified Order for a term of 3 years. According to the school managing committee, Maulakandi Secondary School was constituted.
See, they've annexed they've annexed the order. Where's the order then? You can't read this. Copy orders annex here with Mark 1.
Only they have given this caveat, my
You
lord.
can't have these kind of petitions. You coming and
We are trying, my lord. Notice may be issued during the course of the time. We will.
Yes, we are appearing for the caveat.
Yes, my lord. The caveat, my lord, in the file 21st September 2023, my lord.
No, how are you appearing today?
My lord, my learned senior has served the copy.
How serve copy to you?
My lord, I requested them my learned senior's colleague that already.
It's unheard of this procedure. What kind of some caveat you bring and you challenge you don't annex the impugn order. Suppose the court admits a petition, what are we going to go on? You're going to make the court the roving inquiry, demand them to bring. Are you dismissing it now? Withdraw it. Otherwise, you come with complete materials.
Yes.
This writ petition has been filed, assailing a resolution stated to have been arrived at on 30th/8/2023 for reconstitution of a managing committee. Which schools?
Maulakandi Secondary School.
Maulakandi Secondary School, Phulbari.
No, it is Maulakandi only.
It is? Maulakandi. Okay, well, which district? Yes, okay, West Garo Hills. Stop. Those submissions have been advanced, Mr. Hazarika. There are no materials present in the writ petition
So we will withdraw
for any sort of adjudication. Stop. You withdraw it, otherwise
yeah, withdraw with the liberty to file fresh, my lord, after getting the order.
Yeah, Mr. H. Hazarika submits that praise him not to submits praise. Some defects in the petition, we have to withdraw the same. Praise allowed, but how will liberty file afresh?
Yes.
Praise allowed, matters has withdrawn. How will liberty as praise? How can you file a petition like this?
Item number 3.
Master placement.
Have some respect for the court also. Yes.
No, I thought.
You can't. You're going to use. And I will go myself to Maulakandi School. You want the court to go?
We thought we already applied. We will get it.
Absurdly. Yes.
Lordship, I beg to apologize. This senior counsel is not keeping well, so.
We're dismissing it, Mr. Shilla. Enough time been given this matter.
If it's listed on Friday, my lord. If it's listed on Friday,
Argue it today. Otherwise.
Because, my lord, today morning itself, I informed that senior counsel is not keeping well.
But you agree with the matter, correct?
No, my lord, but I'm also not in a position.
I think.
Just this Friday. Just this Friday, my lord. Just for this.
On Friday, we will not take hearing.
Or any
This
other date.
involves disputed facts, Your Lordship,
Yes.
which is not.
Go to civil court. What is there? It's not
The
that
criminal
we're
court
shutting
you
the
can
door on
go,
you.
yes.
There's only a writ remedy.
There are certain aspects that the senior counsel like to brief this honorable court, my lord. Very serious
We had
aspects.
Thing you do, you file a criminal complaint against that IO or something you have.
Because there are some serious allegation against the private
You can't
respondent.
just,
Yes.
how many times have you changed adjournment?
My lord, today is on the held ground, my lord. That's why. Because
See,
today morning
let's see.
itself they informed that.
Yes, 30th 4. And we give long dates of
Very many dates, Your Lordship, has gone by.
8/4.
And there are a series of lawyers
Not
here, Your
available,
Lordship.
yes. Then
All of
where's
them
Mr. Longpure?
capable
He's been
lawyers, no?
8/4, 14/3.
Lord, just last chance, my lord. If Friday, if it's not there, then we will take up the.
We're not going to give you a choice.
Because on held ground, my lord.
It's not.
We won't give you a date of choice.
No, it's okay. Any date that is
14/3.
that's convenient to this court.
See, one date. This is the 5th or 6th time, Mr. Shilla.
Any date convenient to this court, my lord.
See the last order.
Yes, my lord, I've seen.
Where's Mr. Longpure?
That's why I started with apology, my lord. We really apologize.
You've seen the last order, Mr. Longpure?
No, no, he's not willing to take the bullet today, so I'll be taking down the bullet.
See, you've seen the last order.
Yes.
What's the last order say? Kindly see. Mr. Shilal is well aware of the last order, correct?
Yes, my lord. That's why I start with an apology, my lord. I started with an apology, my lord.
25/2024.
I apologize. Lordship, I apologize. I didn't go through the order, Lordship.
It's in the order, Mr. Shilal.
Yes, I've
It's
seen
the last
my lord.
order.
Yes, yes.
What does it say?
That,
You're not there in the picture or last time.
yes, my lord. Today
You
morning
undertook to
they,
argue the matter today.
because today morning itself they inform us, my lord, that he's not keeping well.
You're not in the matter anymore.
No, actually, my lord, we are here only to assist them, my lord, but it's their matter.
Today also difficulty has been expressed by half the petitioners that we're going to lift the matter after 6 weeks. Yes, expected next day the matter will be taken up.
Bless you.
Give you enough time to recover. Yes.
Item number 4.
Or prepare the matter yourself.
Yes, my lord, we'll do that.
Yes.
My lord, in this case,
Yes.
challenging
Who's
some
appealing
notification of district council, but there's some positive steps taken to settle the matter, my lord.
Yes, Lordship.
You want to close the matter?
No, Your Lordship.
Just give us some more time, my lord. On next date, we'll inform.
Is that correct? You're
No,
appealing
with
for
the private respondent, my lord.
This is private.
Okay, Mr. J. Shilal, the petitioner, Mr. Inaudu. This is for one number 6. What the concern is Wadi.
Yes, Dorbar Shnong.
Dorbar of
Sokumpar Neng.
You're Sokumpar Pochnong.
Yes, my lord.
Submit that settlement talks are going on. They pray that the matter will be done after
3 weeks, my lord.
3 weeks. Yes, let's allowed of only this matter of 3 weeks.
Much obliged.
Item number 5.
Lordship, affidavit on the behalf of the respondent is already filed. Affidavit on behalf of the respondent is already filed, Lordship.
Yes. Yes.
Please, my lord, we have received the affidavit.
Yeah.
I appear on behalf of the petitioner, Lordships.
Yes.
This, Lordships, is, as Lordships will remember, this is the teeth matter, Lordships, where the petitioner was declared unfit for dental
When did you file the
grounds.
affidavit?
Lordship, this was filed on
You received the affidavit?
4th June.
Yes, Lordships, we received it on last Tuesday only.
You don't
It was
reply?
listed for- no, Lordships, we don't seek to file any rejoinder to that.
Ready the matter today? Where Dr. Mosika?
Lordship, he's on legs.
We'll have it next week for addition hearing. We'll dispose it off.
Please, Lordships.
Give a date. We'll sit on. Today is the 10th. Listed on 19th is a fixed matter
Highly obliged.
for admission hearing.
Obliged, Lordships.
Obliged.
So affidavit since has been filed by the respondent. Council of Petition Service and no rejoinder will be necessary. Accordingly, it's a matter for admission hearing on 19th June. Yes.
Please.
Item number 6.
Please, Your Lordship.
Yes.
May it please, Lordship. Lordship, I'm supposed to file the affidavit. There are some defects, my lord. Kindly allow me to file it in the course of the day, my lord.
Let them file course of the day.
Lordship.
Mr. Panthi submits the affidavit on your respondent.
6, my lord.
We file the course of the day. List after 2 weeks for rejoinder of any.
Lordship.
7.
Not item 7. I'm praying for a little, some more time, my lord.
How many times, Mr. Purasaji? Since February, no affidavit.
My lord, we'll try to file it by next.
Now it's June. You're appearing for?
For 6, Lordship.
Who's 6? Management committee. And you want to file? Yes, Mr. Kevarchaji, want to file Mr. S.A. Sheikh for 6. Pray for allowed how much for that time?
My lord, 2 weeks will be sufficient.
2 weeks.
Last chance may be given, Your Lordship.
Last chance is no meaning for people. You have to write a new dictionary what last chance means. Yes.
8.
Yes, Mr.
Oh, this is contempt. I have filed with that.
Let them take the instruction, my lord. There is some development. So let them complete the instruction.
They said only some portion have been paid, but let me get a clear instruction because only just by phone they have called me.
If even
but
was complied, as per my instruction, my lord.
Full amount had been paid.
Now, if that is a fresh cause of action, my lord, then they have
Is
filed.
there any willful violation?
It is not
Would
there,
you
but
say that the violation, the part of the respondent is willful? They've done it on purpose. In spite of having money with them, they're not giving it to you.
Lordship, I'll get the instruction on
No,
the
no,
next
you-
date.
do you
Lordship,
think- one thing is that you say that you see some amounts, correct? Now, will you say is willful disobedience?
This is they have paid that some amount
No,
also
sir,
only after
please listen to the question.
Lordship, not
Is it
willful
willful?
amount.
Not willful.
Not willful, but
Then contempt is closed.
Lordship, but they have paid only after filing of the contempt petition only.
We have paid. He should be happy that we have paid, my lord. Now, after filing this contempt petition, my lord, now he is disputing the amount. If that is the case, my lord, then a fresh cause of action has arisen.
I have not seen how much they have paid also.
Now he is saying how.
But they have yet to get the money. Some order they have called a petitioner because for receiving some money, but he have not received yet. Of course,
he has not told you how much money he's got.
Because he have not seen. He was called from the office that he can come collect and check that. Not exactly verified.
Please allowed 2 weeks time to obtain instructions.
Yes.
As it is submitted by Mr. SD for the respondent that
there's some development, my lord.
That some amounts have been released to the petitioner.
Lordship. The next day, if the amount is paid, I will be.
Thank you very much. Yes.
9.
Much blessed, Lordship.
Yes.
This matter has to be closed down, my lord. We have complied totally with this order of this honorable.
Yes. Party submitted the order is complied. As such, nothing says consideration. Contempt stands closed and disposed of. Yes.
10.
Here, Lordship. Here, in view of the affidavit filed, Lordship, they have annexed some documents saying that it has already been held, Lordship. So I'll just withdraw the liberty to challenge the proceeding, Lordship.
What have they done?
They have selected, Lordship. The
My lord, the issues
five
with regard
selections were
to
made.
non-forming of the VEC, my lord.
Okay.
There were 3 cases. In 2 cases, we admitted that we have not done it. So the lordship has directed, it has been conducted. So whereas this 3rd case, my lord, here we have said that it was already constituted. So we have brought all those documents to record when this VEC was constituted.
Mr. S.A. Sheikh, and the council for the petition submits that has some developments with regard to the constitution of the VEC.
Yes,
Please that we allowed to withdraw the same. Will liberty to file a fresh if a new cause of action arises. Prayer is allowed.
11.
Please, Your Lordship.
Yes.
I humbly pray 2 weeks' time, Your Lordship, to file the affidavit.
It was status of service received
Yes.
on the respondent before.
According to the report, it was showed that on 22nd 4th they have received them.
They have received. Then you filed an affidavit indicating service. You have not filed it as yet. You file an affidavit saying that they have been served. It's MS Kilateb.
Kelitab.
Yes, MS Kilateb for the petitioner submits that the respondent before has been served on 22nd
They have
of
received.
April.
They have already received.
Yeah, they've been served. That's the date they've been served on.
Yes.
On what date?
Date. The 17/5. They have received on 22nd 4th 2024.
Yes, so please was allowed to file an affidavit indicating service stop. MS Raji, behalf of respondents number
1, 2, 3.
1, 2, and 3.
Yes, Your Lordship.
Previous one is allowed further 2 weeks time for affidavit. List after 2 weeks for affidavit and for affidavit for affidavit and for service report.
Much obliged, Lordship.
Item number 12.
May it please, Lordship. Lordship, the respondents are yet to file their affidavit, Lordship. in this
Lordship,
matter.
I'm praying for 2 weeks time, Lordship.
Some matter is disposed. It's not this matter. It's
Not this
disposed
matter,
of
Lord. This matter is pertaining to
connected to
the
the matter.
dispute between the Hima Bhowal and Hima Maharam, Lordship.
You won't file
Whereby-
affidavit.
You will be filing, Lordship.
Non-resident filing.
You will be filing, Lordship.
How many times you've taken?
Second.
5 times.
Last time they wanted to file a petition
times.
challenging materiality.
Yes. When the file petition,
Last
you want to
time-
file objections, telling maintainability, not petition.
Lordship is- will
What do you
be
want to file?
filing Affidavit, Your Lordship will be filing.
Only affidavit.
Your Lordship.
Okay, Mrs. Naitang, please sponsor out further 2 weeks time to file affidavit.
So even the respondent KCDC also. yet-
You're filing, Mr. Kanta?
No, we are not filing, Your Lordship. We will rely
Let them rely on record.
13.
Deputy obliged.
much obliged.
My lord, this is the case of claiming family pension, my lord, by the legal heir, my lord. On the last date, my lord has passed this order that it is noted that the reason for non-payment seems to be very trivial. Accordingly, it is expected that without the need of the affidavit, an endeavor shall be made to
Needed,
dispose.
Your Lordship, the affidavit is needed because
Is needed, why?
some facts I need to bring, Lordship.
No, but the thing is, my lord, in the record, my name and my elder sister's name is there. That's not disputed.
Maybe it is something else which you have not revealed to the court.
No, but marriage, what could be the thing is that two things
Let them
only.
file. They have a
Marriage,
right to file affidavit. Let them file.
Yes.
Though by order dated 23/5/2024.
Yes.
The learned counsel for the respondent number 224 was instructed to obtain instructions. MS E.B. Prasad today submits that an affidavit will be necessary as some facts have been placed on record as to the reason why family pension has not been released to the petitioner. So accordingly, 2 weeks time granted. Yes? Yes, MS A. Pradhan submits that there are formal parties for no affidavit forthcoming from this respondent. Just after
3 weeks, Your
2
Lordship.
weeks, yes.
2 weeks, my lord. Obliged.
Yes.
14.
State they are yet to file counter, my lord.
Where's the
Lordship, we have
instructions?
just received the instructions, Lordship.
What does it say?
We are praying for 3 weeks time.
What does it say, the instructions?
Lordship, we have just received the instructions.
What's the matter about, Mr.
Yes,
Sona?
pension matters, my lord.
Pension matter?
Pension matters.
You retired when?
Retired on 22nd December 2009.
2009?
9 to 23, my lord. 14/12 to 2023.
31st, 2023.
2023, my lord. 14/12/2023.
But here in your synopsis, you say he retired on 31st, 12, 2023. What's the reason? What instructions? What have you said in the instructions, Mr. Sabah?
Lordship, I have not looked at the instructions as of now. It's just been this.
What instructions?
The instructions is in the office, Lordship. I've just received the information right now. The court itself.
This pension matter, instructions are there, we won't keep it pending.
Yes, Lordship.
Just after 1 week, as Mr. G has some instructions were received, just after 1 week of further orders.
Obliged, my lord.
Fully obliged.
Or affidavit, yes.
15.
Both of you have prayed for time in the last occasion.
8, 9 and 10 received.
Yes, Your Lordship, they've received.
What about the others?
My lord, I'm for 1-2 entry. My lord. The issue, the prayer is not against 1-2 entry. My lord. It is the bank and the corporate.
What is the matter about?
Your Lordship, this is that matter regarding the
You have to answer. You're the main.
termination of service, Your Lordship, of the petitioner from the bank.
From the bank?
Yes, Your Lordship.
He's working as what?
CEO, Your Lordship.
My lord, this
This
is
is from
what-
Joy?
My lord,
Matter.
yes, the joy matter, my lord.
What about you are not filing affidavit?
My lord, so far, my lord, the issue is with the bank and the RBI, my lord, because these are the issues that has.
What about Mr. Sheikh?
I pray for time, Lordship.
You're praying for whom?
11, Lordship.
Who's 11?
My the
Private
11 is
respondent,
the
Your Lordship.
respondent.
Deputy.
He's the deputy CEO.
MSZ
Your Lordship.
Inaugury submits that service on respondents 8 to 10
Has
is
been
complete.
received, Your Lordship, yes.
Yes, she's allowed to file service affidavit indicating the same. Stop. Then,
Momentarily, I was disconnected, Lord. Now
yes,
I'm,
Mr. Dubey.
Lord,
They're asking, seeking further time on behalf of 4 to 7 to file affidavit.
Lord, they have already taken twice or thrice, Lord. And in
What
fact, when the
can we do?
state
We are helpless.
Lord, my friend appearing on behalf of the state perhaps had made a statement that they have nothing to do, Lord. Lord, perhaps that statement is not correct, because there is also our prayer that the tenure of the society bank has expired, Lord. Even Lord, even going by the act, even by going by the actual tenure also, Lord, what they presume to be, because 1st May, Lord, it would be from their own counting, Lord. Lord, there has to be a resolution. We have a prayer also, Lord.
Okay.
But
Take
they have
down,
not responded.
Though MSR Goni for response 1, 2, 3 submits that no relief is claimed against them, comma, Mr. R. Dubey, learned counsel, the petitioner, has submitted that perhaps this stand is not correct. Stop. It is directed, therefore, that I was going to receive further instructions with regard further instructions from the said respondents. Stop. Mr. S.A. Sheikh, on behalf of
11, yes, ma'am.
first you on behalf of 4 to 7, praise for further 2 weeks time, MSA Pradhan Vice Dr. M. Mozika, Vice so. So also Mr. S.A. Sheikh for number 11.
Vice Jeshila, Lordship. Vice Jeshila.
Vice Jeshila. Where was he? He was here just now?
Yes, he's another.
Just after 2 weeks, yes.
Lordship,
Has
interim
informed
order.
him that service as regard RBI is complete, Lord. On 14th May, they have received. We are filing our affidavit.
Yes, let them file it. Yes.
Lordship, interim order may continue.
Interim order, if any, shall continue the next day. Yes.
Obliged, Your Lordship.
I'm so deeply obliged.
Please, Your Lordship. Your Lordship requires some more time, Your Lordship, to file an affidavit.
Where's Mr. Devnath? Devnath, formal party only.
Yes,
What's the
Your
matter about?
With regard to settlement of retail outlet, Lordship, whereby my application was rejected
Oh, yes.
due to
Why is it
mismatch.
so long to file the
It's been quite some time, Lordship.
Yes, sir. Your Lordship, there's some instruction. We're waiting from the BPCL, Your Lordship.
Is that uploading
The mismatch in the PAN card.
MS Bijarwa Vice Ms. S. Jindal?
Yes, Your Lordship.
Response allowed further 2 weeks' time. It is seen that the matter has been pending for considerable time without affidavit being filed by the respondents. You list after 2 weeks, interim order, if any, shall continue next year.
Let them file positively, Your Lordship, because
You know very well. You
17.
convince your friends to file it.
Much obliged, Lordship.
Where's Mrs. Sen? You file affidavit?
Yes, I have filed the affidavit. Now, my lord, here is the case, Your Lordship. The FIR registered, my lord, under section, my lord, a very grave offence, Your Lordships. Under, my lord, 354, case registered against him, my lord, under 354 and 376, Your Lordships. Now, my lord, the police incident took place, my lord, in the university.
Within university?
Within the university. My lordship will see the gravity, my lord. And this person was arrested, Your Lordships, on 2011-23, Your Lordships. Then he was for weeks, he was under detentions. Obviously, there was a prima facie case. Investigation is still on. Now, my lord, after he was released, your lordships, my lord, when he submitted, my lord, ultimately, your lordships, in the month of January, he submitted a copy of the bail order before us. Now, my lord, what my learned friend is pointing out, my lord, that 90 days. Now, my lord, within that 90 days, my lord, we constituted a committee to review the extension of suspension, my lord. So that, my lord, I have made a categorical statement.
Have you annexed any of the
I have made a statement, my lord. I have the records. If your lordship want to see records, my lord, no
Why
problem.
you should annex it? What was the finding of the review committee?
My lord, that was 28 March 24.
Which paragraph?
Paragraph 6. Paragraph 6, my lord, in the middle, your lordship will come.
Within 90 days, 28 March.
28 March, within 90 days, my lord, well within
It's not within 90 days, Lordship. Not within 90 days.
28th March.
Because the 90 days period expired on 18 February 2024. Now the review committee is 28 March 2024. It's beyond the 90 days period, Lordship. Beyond the 90 days period.
He was arrested on?
He was arrested on
20.
From when?
He was arrested on 20th
September, my lord.
20th.
No, sorry,
No,
November.
Lordship.
2023.
23, Lordship.
So 90 days will elapse will November, mid-December.
Lordship, as per rule,
Yes.
Lordship, it should be from the date of suspension, Lordship. Rule 10.6 says from the date of suspension. He was suspended on 19/11/23. Kindly see the suspension order, Lordship. That will be at page 19, Lordship. 19 of the writ petition.
Yes. 19.
19. No. 19 November 23 suspended. So the 90 days period expired on 18 February, Your Lordship. Now they are saying that the university has constituted a review committee on 28th, Lordship. It's more than a month, Lordship. Beyond 90 days, Lordship.
Well, I'll satisfy your lordship now.
Now any action beyond the 90 days is invalid, Your Lordship. I have authorities to that effect, Lordship.
If I can take my lord to Rule 10. They have annexed, my lord, at page 31, my lord. 10, sub-rule 6 and 7.
Page?
Page, my lord, it starts from, my lord, page 30. Relevant part will be at page 33, my lord. Rule 10, sub-rule 6 and 7.
33?
Page 33 of the writ petition, my lord. Has got it.
Rule 10.
6 and 7. Sub-rule 6 and 7. If I can read your lordship. 6 is say, an order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension before the expiry of 90 days from the effective date of suspension on the recommendation of the review committee constituted for the purpose and pass orders either extending or revoking the suspension. Subsequent reviews shall be made before the expiry of the extended period of the extension suspension shall not be for a period exceeding 180 days at a time. 7. An order of suspension shall be made or deemed to have been made under sub-rule 1. This rule shall not be valid after a period of 90 days unless it is extended after review for a further period before the expiry of 90 days. Provided that no such review or suspension shall be necessary in case of deemed suspension under sub-rule 2, if the government servant continues to be under suspension at the time of completion of 90 days of suspension, and the 90 days period in such case will count from the date of the government servant detained in custody is released from detention or the date on which the fact of his release from detention is intimated to the appointing authority. So here, admittedly, my lord, he was in detention. This is not our job, my lord, when he was released to know. Ultimately, he submitted a bail order and the representation dated, my lord, January 18th. So if your lordship count from there, we are well within the time.
Lordship, kindly see the proviso, Lordship. And my submission will be that the proviso of subsection 7 will not apply to my case.
Because no review will be necessary.
First, they'll have to comply first with sub-rule 6, Lordship. there should be a review, Lordship. Now, now the proviso of subsection 7 says that, Your Lordship, if the government servant continues to be under suspension at the time of completion of 90 days, Lordship.
Now you mean to say that only if suspension under sub-rule 2, with automatic suspension if it's retained retention,
Lordship.
right?
Lordship.
Now, when he was suspended, was because he was detained or because he was
Because of
arrested?
his detention, Lordship.
Detention. That means sub-rule 2 will come in. If sub-rule 2 comes in, proviso will come in.
No, Your Lordship, kindly see sub-rule 2, Lordship.
Yes, he reads sub-rule 2.
A government servant will be deemed to have placed under suspension by order of appointing authority with effect from the date of his detention. So, date of detention is important, Your Lordship. So far as the review of
proviso says what? Proviso says review suspension shall be necessary in the case of deemed suspension under sub-rule 2 if the government servant continues to be in suspension at a time of completion of 90 days, right? Of suspension and 90 days period in such case will count from the date of government servant detained is released from detention.
she was not
no review will be necessary if you continue to be in detention. Now, and the date for 90 days will be counted after you release from detention.
Lordship, my submission will be that the proviso will not apply to me because I was released on bail on 20th December 23, Lordship. I was granted bail.
December?
Now, my contention is that...
When you release on bail?
On 20th December 23.
So, December, January, February, March,
now, from the date that I was granted bail also, Your Lordship, the 90 days period will expire on 19/3/24, Lordship. Now, their submission is that the committee has taken a review on 28th March, Lordship.
My Lord, that's what, my Lord. If your Lordship look into the proviso, my Lord,
so proviso, if it says also
three parts. It has 3 parts, my Lord, if you can play. Okay. One thing, that 90 days, if it is spanned on detention, no question of review. A person can be more than 90 days also, my Lord. We are not under obligation to review. Another situation, he is released. If he is released, what the proviso is categorically saying, the period of 90 days will start from the date of release or date within, or from the time, my Lord, when it came to the knowledge of the employer. So here is the case, my Lord, by their own statement, they have filed the, my Lord, order of bail before the university by a representation dated 18 January 2024. So you will Lordship count from 18 January, my Lord, 90 days. We are well within time.
We'll hear his matter then, with short date admission hearing.
1 week, Lordship.
1 week or 2, whatever, after it's been filed by the respondents. This matter for admission hearing after 1 week decided.
Lordship, I may be granted liberty to file a rejoinder if necessary.
Yes, liberty. I think rejoinder is necessary because if it's on a point.
Lordship, another ground taken by them is that this ICC inquiry pending against me.
ICC?
There's a sexual internal complaint.
This is obviously has to go, my Lord. That's gone there. Now we're waiting for their recommendation.
What we're saying is that the inquiry has been preceded only after a period of 6 months, which is against the law, Lordship.
Against ICC also? Against the internal
6 months,
committee?
Lordship, because the internal complaint committee should have taken cognizance.
Let him take up all those things.
Regarding this kind of allegations, ICC is the best authority actually to look to it.
Now, another issue is that whether ICC has jurisdiction, because the victim here, the complainant here, she's not from the university.
Not required. I have seen. Not required. Even if a lady visiting
it happens within the premises.
My Lord, that I have checked. In fact, I can say. Anyway, my learned friend can take up all those issues. I'll answer.
Just a week, Lordship, on Monday, Lordship.
I used to chair this ICC of Nehu before.
Yes, sir. I remember.
It's quite. If you fall foul of them, that means your service is gone also. Yes.
18?
After a week, Lordship. Monday. I'll leave, Lordship.
Yes. Yes, Mr. Hassan.
Yeah, please, Your Lordship. Lordship, state respondent has to take instruction with regard to the impugn order selection of the VEC, my Lord. And with regard to the private respondents, we have taken steps, my Lord, on 22nd 5/2024, my Lord.
They've been served?
My Lord, served. My Lord, status is waited, my Lord. We have to.
Yes.
Your Lordship, from my instructions, Your Lordship, it appears that the reason the VEC was extended, Your Lordship, before the expiry of its term was because the secretary, who is the respondent, She's the respondent number 7 here, Your Lordship. She had resigned during the term of the previous VEC. So when she had resigned, Your Lordship, her resignation was accepted, and then the VEC, the headman, Your Lordship, had asked the BDO to hold a meeting, Your Lordship, to constitute a new VEC. So because she had resigned, Your Lordship, so the meeting was held, and at the meeting, Your Lordship, the job card holders unanimously selected the respondent number 7 again, Your Lordship, because initially she had resigned due to ill health. But by the time the meeting was held, Your Lordship, she had felt better. So when she was unanimously selected, Your Lordship, then she became the secretary again, Your Lordship, and the VEC was then constituted, Your Lordship. There was a meeting that was held, Your Lordship, with all the job card holders. If I can place all that on record, Your Lordship, I give an affidavit.
Within 2 weeks.
My lord, yes, my lord. Affidavit is required, my lord.
Required. If this,
my lord is correct.
What about your parent respondents?
My lord, notice already served, my lord.
You served?
Already.
Issued or served?
Yes, issued, my lord. Status report is waited, my lord.
Notice issued.
Notice issued, my lord.
Yes, office note indicates that service yet those reported to be received respect of 6, 7, and 8.
My lord, the last occasion, for interim prayer, my lord, yes, my lord.
But if those are the facts, because we were thinking that, out of turn without any reason,
my lord,
before a term expired,
prima facie, my lord, whatever my learned friend has submitted here, it looks like
manipulation,
cooked up story, my lord. Because again, she is in the committee, my lord.
Oh, no, let those people appear.
My lord is correct. Yes. So my only limited prayer is, my lord, at this stage, at least the functioning of the thing should be kept in event, or maybe given to the, my lord, block development office, my lord. Some officers has to be appointed.
File in 2 weeks. MS Nihali submits that instruction will be received. She brings around 2 weeks time to file affidavit stuff. Next, Mr. S. Hassan has pressed his prayer for interim orders in view of the fact that Mr. S.K. Hassan has pressed is what has pressed in terms of another request for interim orders and submits that from the instructions received by GA, it seems that there has been some manipulation as the same person has come back as secretary of the VEC. Stop, however, as an affidavit appears to be necessary. This is matter after 2 weeks. Yes.
My lord, 2 weeks.
Obliged, Your Lordship.
My lord, bless me.
2 weeks for affidavit for appearance of the private respondents.
My lord.
19.
Hello.
Report and private respondents. What is the matter about?
May it please Your Lordship. Lordship, we have the instruction, we would like to file the affidavit, Your Lordship. It appears, Your Lordship, from the instruction that whatever document have been...
You supply the documents necessary to him?
Lordship, yes. It appears from
Why should you delay the proceedings?
Already given, Your Lordship. Already given.
Already.
Mr. Lord,
some we've received, some, my Lord.
What do you mean some you've received?
My Lord, I'm yet to go through the documents that have been supplied to us, my Lord.
Started by Mr. Shulai?
My Lord, it was given to the petitioner, my Lord.
By a department.
You'll file affidavit, no?
Lordship, 2 weeks' time.
Mr. N.D. Shulai, learned AAG with so-and-so submits that whatever documents necessary for the proceedings have since been supplied to the petitioner. He, however, prays that he may be allowed to place the same affidavit.
Lordship.
On 2 weeks' time granted for affidavit.
Apply, Your Lordship.
You also take instructions.
Yes, ma'am.
Everything, then you can close it and start with your, continue with your.
Yes, ma'am.
Hearing, item 20.
New exemption. You share on the 6th as well. On 6th was the matter taken up?
Lordship?
Did we hear the matter on 6th also?
Yes, Lordship. Yes. Thursday. Yes, yes.
Maybe so careless. Mr. General is still arguing.
Lordships were on the sale deed, if your Lordships recall, the Dulirs.
The sale deed?
In the additional paper book.
I seem there's my notes, something's wrong. I've lost out one date. Can't afford to do that in this matter, you know. Because you said on sale deed, not decree, violation of section 28.
No, Lordships, my learned senior started arguing on the cross objections. And we were on the issue of the prices and the sale deeds, which were presented by them in evidence. So, वही last था ना? Sale deeds पे.
Why can't they? My notes only up to 5th. What cross expression? Sorry, never mind, yes.
Lordship, just to recapitulate my memory as well as the memory of this Honorable Court,
so far collector appeal is concerned, Your Lordship, he has raised 4 points only. The first point which was raised by him was this, that reference court has wrongly granted compensation at the uniform rate. I have already met this question that the reference court was well within its right to award the maximum compensation as per the classification made by the collector himself. The reference court has not made any assessment. Assessment of the rates was made by the collector, categorizing the land into 4 categories, and collector has awarded different rates without giving any justifications. And under the circumstances, the court was well within its right to pick up the maximum compensation and award uniform compensation to all the landowners, put up in one category. That is the case. Then your second point, that which my learned friend has raised, that court has granted solution on the entire amount. That, Your Lordship, I have already conceded that there is a mistake in drawing the decree. The solution should have been granted on the market value. Then third point which my learned friend has raised, that interest is awarded on all the heads. And I have also covered this point by reference to the Constitution Bench judgment, which was referred in 2 cases. And so far 2 cases are concerned, I have already pointed out. And the book for the constitutional case was called for, that is Sundar versus Union of India, 2001, 7 SCC 211.
And how come they got it here? Really strange.
2001, 7 SCC 211.
Yes.
Lordship, what was the reference to the Constitutional Court? Your Lordship will find from paragraph 1. At page 222 of the judgment. May I read, Your Lordship?
Yes.
The question referred to this bench of 5 judges is a simple one. Is the state liable to pay interest on the amount envisaged under section 23(2) of the Land Acquisition Act? That is solution, Your Lordship. The sum contemplated in the aforesaid subsection can conveniently be called solution, as that expression has been used plentifully in almost all land acquisition proceedings in India. The reference of the aforesaid question to the larger bench was necessitated on account of seeming conflict as between the decision of a 3-judge bench of this court in Union of India versus Ram Meher on the one hand, and a few later decisions of co-equal benches of this court on the other hand. Your Lordship, the reference is very clear here, what was referred to, and how it was answered, Your Lordship, will come to paragraph 14, 15, 16. Question of payment of interest would arise only when the compensation is not paid or deposited on or before the date of taking possession of the land. It is inequitable that the person who is deprived of the possession of the land on account of acquisition proceeding is not given the amount which law demands to be paid to him. Any delay thereafter would only be to his detriment. There must be a provision to buffer such inquiry. It is for the purpose of affording relief to the person who is entitled to such compensation when the payment of this money is delayed that the provision is made in section 34 of the Act. That section is extracted below. Section 34 is extracted. I am coming to paragraph 15. When the court is of the opinion that the collector should have awarded a larger sum as compensation, the court has to direct the collector to pay interest on such excess amount. The rate of interest is on a par with the rate indicated in section 34. This is so provided in section 28 of the Act, which is extracted below, Your Lordship. From paragraph 15, Your Lordship will find it that even when the court is of the opinion that the collector should have awarded a larger sum, on the larger sum also the solatium has to be paid and interest. Section 28 is quoted. Then I come to Your Lordship, paragraph 16. Thus, interest has to accrue as per section 34 and section 28 of the Act on the compensation awarded, whether it is as per the award initially passed by the collector or by the court later. What is meant by the compensation awarded? Both sides cited different definitions for the word compensation as contained in different lexicographics in words and phrases. Different connotation of the word compensation have been delineated. One of them relates to the law of eminent domain, where compensation means recompense in value. Your Lordship, this is the same thing, Your Lordship, and I have already explained that there is a lot of difference between compensation and the market value. Market value is only one component, and compensation includes many other things, Your Lordship. These Constitution bench judgments, Your Lordship, was followed in other cases, and I have pointed out 2 cases. Then, Your Lordship, another point which my learned friend has raised, that award of interest 15% is discretionary, and I have also replied to this that under the facts and circumstances, there was no scope for the court to consider the interest less than 15%, Your Lordship. Your Lordship, I have prepared a list of dates for the convenience of the court, and from the list of dates, Your Lordship will find that how and in what manner at each and every stage, state has defaulted, collector has defaulted, Your Lordship. And after having answered all the 4 points which my learned friend has argued, I have started arguing the cross appeal.
Yes.
Now, the cross appeal, Your Lordship, it's not a cross appeal, cross objection has not been filed by all the respondents. First thing, Your Lordship, I will point out that some of the respondents have not joined and they have filed the separate appeal. For the reason which is explained in the independent appeal, that if this appeals, collector appeals fails on the point of maintainability, then the counter objection also goes. And in that view of the matter, these counter claimant will again have to take recourse to the law by filing a separate appeal or one appeal consolidated. Since this apprehension was there, some of the people have not joined in the counter, as a counter claimant in FA number 1, and they have filed the separate appeal. Those separate appeals also raises the same questions which are raised in the counter objection in FA number 1 against the FA number 1, Your Lordship. So, Your Lordship, I have 6 independent appeal. Now, first appeal is item number 20, 21, and item number 21.
Item number 21, item number 23, 24, 25, 26.
Which में नहीं है एक?
22 is cross appeal.
Yes. Those independent appeals are, Lordship, item 20, 21, 22 is the cross objection, and item 23 is a separate appeal. Item number 24 is also a separate appeal, then item 25 and 26, Your Lordship. Now, in all the cross objection and the independent appeal, everyone has claimed enhancement of rates. Now, enhancement of rate, the first point which the counter claimants are raising, that the learned reference court was not justified in rejecting the sale deeds, Exhibit 4, 5, 6. When the state has raised no objection, and the objection raised only was with regard to only one thing, that these sale deeds are not stamped, are not registered. I have also pointed out to this honorable court by taking to the court that there are 4 points on the basis of which the trial court has rejected or has not considered the sale deed. The first point was that it is unregistered and unstamped, and second objection was type of land in the sale deed not mentioned.
Yes.
Third one was area in the sub-deeds extend only to a small area, and number 4, not executed at the relevant time. Relevant time means the sale deed relates to the period of 1993-94.
So relevant time is time section 4 notification.
Yes, Lordship. And notification was issued in 2001.
Yes.
Now, court has relied one judgment of the Supreme Court. Your Lordship will see para 138. No, sorry, page 138
of
volume 1. I'm sorry, Your Lordship, page 137. Lordship, as per Honorable Supreme Court ruling recorded in AIR 1995 SC 840 para 7, 14 and 21. The claimant is required to discharge the initial burden of proving that the amount of compensation determined in the award under Section 11 was inadequate. But when the claimant will succeed in proving that the amount determined under the award of collector was inadequate, the burden of proving the correctness of award shifts on the collector, who has to adduce sufficient evidence in that behalf to sustain such award. Court cannot determine the value of land unless it gets over the finality and conclusive evidence attributed to it under Section 12 by recording a finding on consideration of relevant material therein that the amount of compensation determined under the award was inadequate, so and so. Assuming that Exhibit 4, 5, 6 are the sale deed duly registered, but the area as per the sale deed, so and so. This I have already read, Your Lordship. Come to paragraph page 138. The above setting ruling herein above at para 14 and 22 thereto with the relevant portion thereof, where a sale deed or an agreement to sell relating to a small extent of land is produced by the claimant in the inquiry held for determination of compensation payable for his large extent of land, the court is not always bound to determine the market value of such large extent of acquired land on the basis of the price fetched or to be fetched by small extent of land covered by such sale deed or agreement to sell. The court has relied this para only, and on the basis of this, the court has not considered the sale deed. Your Lordship, this judgment is annexed in my compilation.
Judgment of this 1995 judgment?
Yes. Here. Page 185. The last judgment. The court has not considered para 13 of the same judgment. I am relying on para 13.
Yes, you're looking at 26, yeah, 1995.
No, but same she has referred to the AIR citation, and I am referring to SCC citation.
995 sub 2.
Yes, Lordship.
It's equivalent to that.
168, same, equivalent to that. I checked up.
182, 168.
Pardon?
160.
168.
168, Lordship.
Special land acquisition officer and another.
Yes, special land acquisition officer and another versus Sidapota Omnens. I have given this judgment as serial number 25.
Yes.
Paragraph 13, Your Lordship, is not considered.
By the special officer?
Yes, Lordship. Where the court has to determine the market value of large extent of acquired agricultural land, it may not be desirable to be guided by the price fetched by a sale of small extent of agricultural lands, as the possibility of genuine agriculturists buying such small extents for their cultivation purpose is rather remote, and it may also not be desirable to determine the market value of the acquired agricultural land on the basis of the value fetched by sales of small extent of agriculture land, even if they had been purchased for building purpose, for that would involve the consideration of too many imponderables. Then next sentence is important, which I am relying. However, if sale deed or agreement to sell relating to small extent of land on the basis of which the market value of the large extent of the agriculture land has to be determined is a portion of the acquired agriculture land itself or other land in its close proximity, it may be made the basis for determining the market value of the acquired large extent of the agriculture land, but has to be done when there is a satisfactory evidence of the absence of sale or agreement to sell of bigger extent of land pertaining to the acquired land or other lands. While sale deed, Your Lordship, I will point it out that these sale deeds relates to the area.
But that's just one of the objections only. Is other things unstamped, unregistered?
No, I'm meeting all those. I'll satisfy your that none of the objection is sustainable. The objection with regard to that the sale deed in question, since these sale deeds were small extent, and the court relying upon this judgment on a particular paras, has held that court is always not bound to consider those sale deeds. Now, there is a exception carved out in para 13, which says that if that sale deed relates to the acquired land,
yes,
even if it is of small extent, it can be made the basis for
yes,
awarding the compensation. Now, another objection, Your Lordship, which is raised, that the classification of the land is not done in the sale deed. Your Lordship, on the last occasion, I have pointed out two judgments at serial number 7 and 8 of my compilation. Seven and 8, which says that land acquired for single use classification is irrelevant. Here, rejection of my sale deed on the ground that it doesn't say at whether the land is agriculture land or it is arable land or it is a homestead land. The higher courts have said that when the land is acquired for single use, it's not the categorization of the land is not relevant. Then, Your Lordship, small area also I have dealt with, and unstamped and unregistered, I'll just delete. Other one is not executed at the relevant time.
yes.
Your Lordship, so far this is concerned, Your Lordship will have a look on judgment at serial number 19. Yes. Page 153.
Fair market value.
Yes, Your Lordship. Para 27.
1 second.
Para 27, Lordship, is at page 163. As rightly argued by the learned counsel for the respondent, the fair market value of the acquired land is required to be determined under section 23 of the Act on the basis of the market rate of the adjacent land, similarly situated to the acquired land prevailing on the date of acquisition or the land prior to acquisition.
What para reading?
Para 27, Lordship.
As rightly argued.
Yes. Should I read it again, Lordship?
Yes, please. As rightly argued by the counsel respondent.
Just a
fair.
minute.
Yes.
As rightly argued by the learned counsel for the respondent, the fair market value of the acquired land is required to be determined under Section 23 of the Act on the basis of the market rate of the adjacent land similarly situated to the acquired lands prevailing on the date of acquisition or and prior to acquisition but not subsequent to the date of acquisitions. In appropriate cases, addition of 10% per annum escalation in the prices specified in the sale deeds, if filed and relied on in relation to the adjacent similarly situated land for fixing the market value of the acquired land may be permitted. Such is, however, not the case in hand. Here is the case where firstly no sale deeds were filed by the appellant to prove the fair market value of the acquired land, and secondly, what they want this court to do is to take into considerations the rate of those land which are acquired 10 years after the date of acquisition, which were acquired 10 years after the date of acquisition in question, and then reduce the value of such land by 10% every year so as to determine the fair market value of the acquired land. Your Lordship, acquisition in 2001, sale deed of 1993-94, 10% escalation, the court says, can be taken into consideration, Your Lordship. Now, sale deed, and this also further is subject to the wisdom of the Honorable Court, Your Lordship, that what rate Your Lordship will determine on the basis of that, on the basis of those sale deed, whether Your Lordship will say, we may say that it is considered to be 50%, but sale deed cannot be rejected. If the state has admitted and they have raised no objection with regard to those sale deed, save and except one objection that it is not registered, which I will deal with it, the court ought to have accepted and making this sale deed as a base, using her own wisdom, ought to have decided some market rate. And here in the instant case, court has not exercised its power to determine the rate. Court has taken the assessment made by the collector and found that there is no justification of awarding the different compensation for the same classification of the land, Your Lordship. Now, if those sale deeds, Your Lordship, are taken into considerations with 10% of the increased value, then due to some other imponderable factors, etc., Your Lordship may reduce to 50% or any percent which Your Lordship deem fit and proper, Your Lordship. But sale deed has to be accepted. Another point, Your Lordship, that sale deeds are unregistered and unstamped.
Yes.
Stamp Act, Stamp Act.
So you say that fair market value, if 10%, right? And then the other one is that if the area
is
the sale of the if the sale deed has been brought concerns a small portion of area of the acquired land, and that is a fair index.
Fair index, Your Lordship. Okay. Can be considered. That's what Your Lordship Supreme Court has said it, Your Lordship. Now,
Because single use, right? Fair market value, single use. Now, right? Okay.
Yes.
Now,
I'm coming to that sale deeds are admittedly unregistered and unstamped, but marked as exhibits without any objections. Your Lordship will just first have a look on Section 36 of the Indian Stamp Act.
just give 5 minutes, Mr. Jindal. We can. How much can? Indian Stamp Act. Sorry, I have to make some urgent calls also. Yes.
Stamp Act.
Section?
Section 36.
Section?
36. I'm reading, Lordship.
Now, only one thing. These CLDs were made how many years before?
93,
the
94. 94.
Section?
Section 36. Admission of instrument where not to be questions. Where an instrument has been admitted in evidence, such admission shall not, except as provided in Section 61, be called in question at any stage of the same suit or proceedings on the ground that the instrument has not been duly stamped. Your Lordship, language is very clear. Once it is admitted in the evidence, and here is a case when the sale deeds are admitted in the evidence and the case proceeded on the basis of those admitted documents, then it cannot be called in question at any stage. Save and except under Section 61 is not relevant here.
Yes. What is the difference between duly stamped and registered?
There is a duly stamped and registered. I'm coming to that, Your Lordship. So, I refer to Your Lordship in this connection the Constitution Bench judgment at serial number 9, page 75 of my compilation. Para 4. Para 4, Your Lordship, is a long para at page 76. The last 3 lines, where an instrument, at page 76, the last 3 lines, where an instrument has been admitted in evidence, such admission shall not, except as provided in Section 61, be called in question at any stage of the same suit or proceedings on the ground that the instrument has not been duly stamped. This section is categorical in its term that when a document has once been admitted in evidence, such admission cannot be called in question at any stage of the suit or the proceedings on the ground that the instrument had not been duly stamped. The only exception recognized by the section is the clause of cases contemplated by Section 61, which is not material to the present controversy. Section 36 does not admit of other exceptions. Where a question as to the admissibility of a document is raised on the ground that it has not been stamped or has not been properly stamped, it has to be decided then and there when the document is tendered in evidence. Once the court, rightly or wrongly, decides to admit the document in evidence, so far as the parties are concerned, the matter is closed. Section 35 is in the nature of a penal provision and has far-reaching circumstances, and the party challenging the admissibility of the document has to be circumspect, and the party challenging the admissibility of the document has to be alert to see that document is not admitted in evidence by the court. Then I skipped one or two. Then once a document has been marked as an exhibit in the case and the trial has proceeded all along on the footing that the document was an exhibit in the case and has been used by the party in examination and cross-examination of their witnesses, Section 36 of the Stamp Act comes into operations. Once a document has been admitted in evidence as aforesaid, it is not open either to the trial court itself or to a court of appeal or revision to go behind that order. Such an order is not one of those judicial orders which are liable to be reviewed or revised by the same court or court of superior jurisdiction. The Constitution bench judgment of five judges is very clear. Then, Your Lordship, another judgment, Your Lordship, I would take at page 78. Paragraph 12 and 13.
Madras High Court.
Sir?
Madras High Court.
Madras High Court, Your Lordship. Your Lordship, paragraph 12 and 13.
What does CTC?
Sir?
What does CTC mean?
क्या है? Current Tamil Nadu cases.
Current Tamil Nadu cases?
Cases. It is down written by at page 78.
Oh yes, current Tamil Nadu cases.
Current Tamil Nadu cases.
Para,
Your Lordship, 12 and 13. But once an unstamped instrument is admitted in evidence, it shall not be called in question at any stage of the proceeding of the suit on the ground. The same thing, Your Lordship, which the Constitution bench has held. Then come to Your Lordship, paragraph 14. There is no provision under the Registration Act similar to Section 36 of the Indian Stamp Act 1899 to debar future challenge of an instrument already admitted. When the admissibility of the unregistered document Exhibit B1 is challenged by the plaintiff, then the defendant has to establish that the said unregistered document has been marked to establish a collateral transaction, which transaction does not require registration, Your Lordship. Then here in this case, Your Lordship, come to paragraph 21. Before that, I may draw the attention of this court at para 17 also, first line. In the instant case, true it is that the trial court had mechanically marked Exhibit B1, which is an unstamped and unregistered Xerox copy of the release deed. Then come to para 21. In view of the above, the court finds that though the trial court has committed an apparent error in admitting an unstamped and unregistered release deed, the same cannot be questioned by the other side, who was also a party to such a lapse at the time of marking the document in the face of the embargo found under Section 36 of the Indian Stamp Act. At any rate, the relief of recalling the document which formed part of the evidence is not at all sustainable in the eyes of law. Here in this case, the document in question was both unstamped and unregistered and was accepted in the evidence, Your Lordship. Then next case, Your Lordship, and one more thing is decided by this court, that a unregistered document can be used for a collateral purpose.
No, collateral purpose means that if another dump has been registered.
Yes, to prove the transaction.
Has already been registered, the collateral purpose, then another document is made, does not mean it has to be registered again. But there has to be the existence of a registered document, I think. That presupposes that. I don't know, that's my understanding, I might be wrong. Yes.
which is there in page 6, at page 81. What is the collateral purpose has been discussed by the Supreme Court in KB Shah's case.
81.
At page 81 of this paper book itself.
Page 81.
As 81, can you see towards the bottom at para 9, KB Shah versus Development Consultant Limited.
Here, Your Lordship, we are not using the unregistered document for a transaction, that for establishing the title. We are using it only for the purpose of a collateral purpose, that such a transaction was made for a sale of land at this rate and this village. By
Unstamp will mean a kacha paper.
Beg your pardon?
Unstamp will be a kacha sale deed. That means.
That
Unstamp, that means a kacha sale deed.
maybe kacha sale deed. Yes, because yes, I know, Your Lordship, because first a kacha sale deed is executed, then they go for final sale deed. Final sale deed.
So the kacha sale deed being executed will be once admitted
Yes,
evidence.
yes.
Will
It's the end of the show. End of the show. And with regard to the unregistered, Your Lordship, my submission will be this, that it can be used for a collateral purpose, Your Lordship. And what is collateral purpose?
Collateral transaction is independent of the one that you want to show.
Yes, Lordship. It is independent, Your Lordship. And it cannot be, unregistered sale deed cannot be used for the purpose of conferring a title.
Collateral purpose, I'm not getting the concept of it.
No, I'll make it, Your Lordship, little more clear. Your Lordship will come to page 85. Page 85, paragraph 8. The endorsement of cancellation on the back of the sale deed in favor of the Rajana, Your Lordship got it? Page 85, relevant para 8.
Yes.
The endorsement of cancellation on the back of the sale deed in favor of Rajana dated so and so has been held, as already stated, to be inadmissible in evidence, as it is not registered. The result of it is only that there was no retransfer of title by Rajana to the second defendant, and the family would in consequence continue to be the owner, and that is why the appellant is entitled to redeem. But the endorsement taken along with the sale deed by the second defendant in favor of the first defendant is admissible in evidence to show the character of possession of the latter. So it is used for the purpose of proving that I am in possession. I am in possession. To that extent, Your Lordship, even if a sale deed is unregistered, it can be used for other collateral purpose. This is, Your Lordship, settled law. There are...
see that this is the value of the land. That's collateral purpose.
Yes.
Okay.
Well, Your Lordship will just have page 122 also. It's a full bench judgment of the Calcutta High Court. Paragraph 12. Para 12, your lordship, is at page 126.
Yes.
Section 49 bars the reception in evidence of a document of transfer, which is required to be registered under Section 17 of the Registration Act or under the Transfer of Property Act, but not registered. It does not lay down any prohibition in respect of transfer required to be registered under other enactment. It is therefore apparent that the bar provided for in Section 49 relates to an unregistered document of transfer required to be registered under Section 17 of the Registration Act or under the Transfer of Property Act. The proviso is an exception to Section 49, and it provides that the bar to the reception in evidence of an unregistered document of transfer will not apply in certain cases, as the Kobala in question is required to be registered under Sections 26C of the so-and-so Act, is admissible in evidence for purpose other than for establishing title, Your Lordship. Other than title, it is admissible. Then Your Lordship will just have a look on page 131 also. This is a Kerala High Court judgment, para 7. Para 7 is at page 132. Para 7 at page 132. Therefore, assuming without deciding that Exhibit A2 document proposed to effect the immovable property comprised therein as a sale, but document shall not operate so as to affect that property, and it cannot be received in evidence of any transaction affecting that immovable property. The plaintiff also have no such case, nor have they sought reception of the same in evidence to prove any transaction affecting the immovable property mentioned therein. They rely on that document to establish payment of rupees 300 and the contract for sale of that property for a price of rupees 350 as sworn to by PW1 and 2. The document Exhibit AB2 can be received in evidence for that purpose, Your Lordship. Here in this case also, Your Lordship, I am not relying those sales.
I think collateral purpose only for proving the price of the land.
Price and the
Section 36.
Yes, and that it relates.
And then registration not necessary because you've admitted to evidence. So
yes.
And collateral purpose only for establishing the rate.
Yes,
registration
Your Lordship
is not,
has rightly got. And so, in view of this, Your Lordship, the court ought to have not rejected my.
What are the findings of the court in rejecting it?
Yes, Your Lordship, I have just take to Your Lordship finding. Page 136.
Of paperbook number 1?
Yes, Lordship. Page 136, last para. From the evidence of claimant number 1, it's seen that the sale deed as commonly relied by all the claimant at Exhibit 4, Exhibit 5 and Exhibit 6, which are all undisputedly not registered and unstamped, but the documents are also not executed at the relevant time of acquisition hearing. But the same was relied for the rate of acquired land herein at projected rates on assumption of rise of rates since 1993-94 as per the sale deed to 2003, expectedly to rise, especially with the hike in price due to coming of four-laning highway. For what purpose I am relying, it is specified. But on perusal of the said Exhibit 4, 5 and 6, it is seen not only the rate is at variable from one another and not specific rate, but the lands therein are also not specifying on the type and classification of the lands therein, so that to enable this court to compare the value of the land of the claimant herein, the acquired lands herein being referred commonly for all 68 referred claimant for a large extent of acquired land of 2,80,000 plus square meter, and the claimant number 1 admitted the extent of his land to 2106 square meter, while the sale deed brought for supporting their claim of enhancement of rate is but of small extent of land. As per Honorable Supreme Court ruling, Your Lordship, I have already read this one, and the claimant is entitled to discharge the initial burden. This is also I have read, Your Lordship. Then last para, assuming that Exhibit 4, 5, 6 are the sale deed duly registered, but the area as per the sale deed at Exhibit 4, 5, 6 extends only to their area therein as so and so square feet respectively. For that also the court is not always bound to determine the market price of the large extent of the acquired land on the basis of the price fetched by the alleged sale deed of Exhibit 4, 5,
But
6.
if they given a maximum rate of 160, whatever it is, they said that's all arable land, so they've given,
Yes.
given that rate, yes.
And that rate is not...
it's very difficult to discern because smaller portion of land which is not, I think, touched by the judgment, and larger portion of land, the consideration totally different. But that anyway, it just says that this was small, so don't apply.
And whatever objection Your Lordship has been stated in the judgment, I have already met, there are 4 objections on the basis of which the learned court was not inclined to accept my sale deed, Your Lordship. Then what is, and the state has not adduced any evidence in rebuttal or otherwise, and they have not.
We'll send it back.
No, that Your Lordship will see
Yes.
that
We are sitting first appeal.
22 years.
We're sitting first appeal, so we can appreciate the evidence also and send it back.
22, Your Lordship will see.
We'll frame additional issues, questions, and we'll send it back for...
No, that Your Lordship will be again putting this poor landowner to a maximum possible misery, Your Lordship. And
no, we have to arrive at a judicial decision. We have to arrive at judicial decision now. The way that this appeal has been conducted.
No, Your Lordship.
Before this budget, it's really abysmal. No written statement filed, no evidence from the part of the collector. This is something which, and even then, just off the record, looking at the rates have been given the they've been given very generous rates with regard to, maximum they've taken that benchmark of,
Yes.
of
Yes.
some interested party who's
Yes.
achieved the greatest rates. So
Yes.
that benchmark's been given to everyone.
That Your Lordship is true, but this
Yes.
court being the court of first appeal,
Court of first appeal,
they
that's
had to
why-
appraise
first appeal.
the evidence on the
Exactly,
record
that's why.
and pass. And I would humbly request Your Lordship, whatever Your Lordship will decide, to your good wisdom, that should make an end of the thing, Your Lordship. and 22 years is not a...
Sitting first appeal also, you see, we're sitting, what is the duty of a court first appeal?
Yes, Lordship, some amount which your Lordship will feel on the basis of these sale deeds, and supposing the 3 sale deeds rates if are taken, and the rate is one rate is arrived, your Lordship may consider it 50% or more, and put a end of the show, your Lordship. And sending these matters again to the trial court will add to the misery. 50% original claimants have already died, your Lordship, without seeing the fruit. And they are fighting these litigations from the last 22 years.
Now, from the sub-registry, there must be some registered documents that are available with regard to the value of the land.
Your Lordship, when they fail to bring any such
of
thing.
course they fail. That will go against them.
And we cannot give them another an opportunity to bring all those things, whatever they have. Even the High Court has passed the directions. They have not complied even those directions. And from the list of date, your Lordship will find the matter was pending for 3 years for filing the written statement or making the measurements and putting the bench boundary marks, your Lordship. And thereafter for evidence, it was kept 4 years pending, your Lordship.
Now all have taken the money.
50% is gone.
No, 50%.
50% is paid.
They all received.
They have received.
Okay,
they have received. Same and except 1 or 2%.
No, don't take what I'm saying seriously. I'm just saying, just airing, the things, because the way it's been conducted, I mean that if...
that's why your Lordship...
absolutely, no court in his right mind would place any reliance.
Yes.
That has been, if that is the consideration, for fixing... This court has rejected, fine. But then, the way it's been admitted for evidence also, that is... Anyway.
And...
What about there was no assessment for the trees and...
No, that I am coming, your Lordship. Next point is this only, last point.
Okay.
That there were cultivations.
Yes,
and
there was
there were structures standing on the land which were not assessed.
Because even if under 2013 Act, it will be 10 times the amount they're getting now. They'll get 10 times the amount. If it's under the new Act.
Yes, your Lordship. Under the new Act, if it is there, then that part also your Lordship will think it, that under the new Act, your Lordship has rightly pointed that it will go.
This is just off the record, like I said.
Yes, I am also your Lordship of the record.
No, we are alive to that fact. That's the thing.
And there are ways, your Lordship, in which your Lordship may consider that they don't go empty hand from this court, your Lordship. And then your Lordship, I come to the next point, that damage to structure बुलाने का लो damage to structure कौन सा केस है damage to structure no for all the cases we have made the chart now. Lordship, just leave us.
But was it factored in this? I mean, the trees, the price, was that factored into the compensation?
Yes, that your Lordship, I'll just...
No, you have any quarrel with the...
Yes, Lordship.
The value is fixed on the
what has happened, your Lordship, there were 3 types of things, which I have given a chart also. There are cases, नहीं मिला. There are cases where there were standing structures which were not assessed because boundary demarcation was not done, and therefore the which area the road will go, whether it will go mid of the paddy field or mid of the acquired land, or it will go left side or right side, that was not known. Now, reference court has compelled the collector to make the measurement and put the boundary pillars. When the boundary pillars were put, then it was found that there are structures, there are plantations. Then the claim was made. Then they were asked to file the reply. They have not filed the reply. They said it is a matter of evidence, and accordingly the court passed the order that these are matter of evidence. Let the claimant proceed with the evidence to prove the damage to all. Now, we have examined the expert witness. The first category of expert witness were the civil engineer who has assessed the structure and made the assessment and issued the assessment certificate. Those are accepted by the court, but the court gave 50% of that assessment. Now, my grievance is this, that when the expert witness has come and gave his assessment, no rebuttal from the state, the court ought not to have deducted 50% of the...
It's just without any reasoning?
Without any reasoning. In one or two matter, it is, some reasoning is given. I will show to your lordship that there is no valid reasoning, your lordship. And the state has not raised any point in rebuttal. Now, supposing if your lordship we find that this court also cannot go on the basis of the unregistered and unstamped sale deed, and what is awarded by the tribunal, by the reference court is correct. Interference, your lordship, if it is done with regard to the 50% cut state in all the cases, and similar position was there with regard to the forest product trees and hybrid cultivations. Now, three categories of list, have you got it? Only rebel. वो क्या वो कहाँ है? हम लोगों ने फाइल किया था, अलग से सेपरेट, देख उनकी भी वो जो क्रॉस अपील में देखो, क्रॉस अपील में Your lordship will see at page 21 of my cross objection.
Where is it?
21. Page 21 of the cross objection, registered as cross appeal number 01 of 2023.
1 second.
Marvelous saying.
This is on the point of trees.
No, on point of all. I'll point out. Page 21.
Yes.
Now, this is for damage to structure, building, etc. Now, these are the cross-objector which are claiming the balance amount according to the assessment certificate, because court has deducted 50%. Court has deducted 50%. We are claiming the 50% what is deducted by the court. And apart from this, counterclaimant.
Okay, let's see. Nature of damage such as building. Amount claimed 5,90,000. Awarded 2,99,000.
Yes, half
you mean
of
to
this.
say that in all the cases half is awarded?
Half is awarded. Half is awarded.
These assessments were done by whom?
This assessment is done by qualified engineers. And I'll take to their evidence, Your Lordship, and one by one. Now, for this, Your Lordship, structure, damage to the structure, building, etc., we have examined two witnesses, that is CW4 and PW4 and PW. Sorry,
CW.
Lordship. CW 72 and 73 for structure damage.
Who are these? They are structural engineers.
Your Lordship will come to page 10 of my additional paper book. Statement on affidavit, page 10. Lordship got it? Statement on affidavit of common witness number 72, namely Shri Winter Rose Lindo.
Was this witness cross-examined?
Yes, cross-examined. Statement on affidavit of common witness number 72, namely Shri Winter Rose Lindo, Assistant Engineer Civil, in respect of petitioner number 1, 4, 6, 15, 20, 22, and all these are mentioned, Your Lordship. I, Shri Winter Rose Lindo, son of so-and-so, aged 57 year, occupation Assistant Engineer Civil, Northeastern Hill University, Shillong, do hereby solemnly affirm and declare as follow. That I am the Assistant Engineer Civil, and in that capacity I am working in the Nehu, Shillong. I am conversant with the procedure of assessment of rates of building, structure, etc., standing on the land. I have made physical assessment of the buildings, structures, etc., standing on the land acquired by the opposite party for National Highway Shillong Bypass in respect of the petitioner's number so-and-so in the instant case, and issued the assessment certificate to them. The assessment was made by me as per the schedule of rates PWD building on for 2004-5. Your Lordship, this is important because the reference court said that these cannot be accepted because schedule of rates is not mentioned. But in his evidence, he has categorically stated the assessment was made by me as per the schedule of rates PWD building for 2004-5 prevailing in the state of Meghalaya, after physical verification of the land, building, structure, etc., prior to the dismantling of the same by the opposite party. I have come before this honorable court to prove the assessment certificate issued by me to the above mentioned petitioner in the instant case, and the details of which are given below. Exhibit P133 filed in the Court of Special Petition in respect of petitioner serial number 1. Then he all exhibits in respect of each and every claimant, Your Lordship. Then, Your Lordship, I'll take to page 17. He says that the statement made by me in the instant affidavit are true. Then Your Lordship will see the cross at page 18. There was no application made by the 21 number of petitioner in this case to me to assess the value, to assess and evaluate their land. And I have assessed their land and issued certificate exhibit P13 on their verbal request only. And the authorities of NEHU under which I am working has not authorized or deputed me to assess the land of the petitioner. It is not a fact that being an employee of NEHU, I am not authorized to assess or evaluate the building or land privately by myself. I do not know in which year the land building of the petitioner were acquired by the government. It is not a fact that in the year 2007, when I issued the valuation certificate of the building land, there was no building structure standing there on the said land. Safe and kept, Your Lordship, there is nothing substantial in the cross-examinations. And the collector has not adduced any evidence.
This is 30th March.
He gave the evidence on 30th March 2012. He gave the evidence. And Your Lordship will see the another engineer who has given the certificate, assessment certificate, only in respect of serial number 24. And so far the second witness is concerned, Your Lordship, at page 19, and the cross-examination is at page 21. Cross-examination by Sri I.C. Jahad GP for the collector declined, Your Lordship. With regard to one witness, they have put one or two questions, but those are having no substance to damage the certificate which are issued by the engineers. But with regard to second witness, who is also a civil engineer, they have declined the cross-examination. Cross-examination, Your Lordship. Now, with regard to Your Lordship, there is horticultures. At page 23, Your Lordship, at
of
page
your cross appeal, of your additional.
Yes, Lordship.
Yes.
Cross objection.
Yes. At page?
At page 23. Cross objection. 23 of cross objection. Not this. Cross objection. That memo.
Swarm with paper. Be difficult to reconcile to,
Page 23.
Chart C.
Chart C. compensation for damage to agriculture, horticulture, and forest product. These are the persons who are claiming the balance 50%, what is cut by
Who did the assessment of this horticultural and agriculture?
Yes.
Produce?
Lordship, 74 is, yes. Yes. And in support of my claim, with regard to Chart C people, I have examined two witnesses, CW 74 and 75. Your Lordship will see page 22 of the additional paper book. Statement on affidavit of witness number so-and-so, Shri Andrew Lindo, Divisional Forest Officer, Shillong, in respect of petitioner number 1 in the instant case. I, Shri Andrew Lindo, of son of so-and-so, aged 56, that I am the qualified Divisional Forest Officer of the Khasi Hill Division, Shillong, and I am conversant with the procedure of making the assessment of the forest product. I have made physical verification of the land of petitioner serial number 1, namely Shri so-and-so, which was proposed to be acquired by the opposite party for national highway Shillong bypass at village so-and-so. On my physical verification, I found that there were 160 number of Tita Champa class 1A trees standing on the land. I have made the assessment of the said tree as per schedule of rates of royalty on forest product, Government of Meghalaya, effective from so-and-so date. Department of Forest Environment, Meghalaya, and issued the assessment certificate in respect of the same to the above petitioner. That Exhibit P12 is the said certificate of assessment and Exhibit P121 is my signature. That the statement made in the instant affidavit are true to my body and so-and-so. And what is cross here? I know the petitioner number 1 in this case, who is the Armstrong same. The petitioner did not submit any application to the Office of Divisional Forest Officer to assess this land, but has only made a verbal request to me in the year 2007. I do not agree that in the year 2007 there were no trees standing in the land of the petitioner number 1. As the construction of the road for which the land had been acquired has already been started, Your Lordship. This is the only thing. They have not challenged the assessment certificate and adduced no evidence in rebuttal to show that construction was already started. Then Your Lordship will come to page 25. I have examined one witness, CW 75, namely Shri Evangel Shampru, retired district horticultural officer in respect of petitioner number so-and-so, so-and-so. I, Evangel Shampru, so-and-so, aged 60-year occupation, retired district horticultural officer, Ribhai, district Nongko, resident of so-and-so, do hereby solemnly affirm and declare as follows. That during 2007, I was posted as District Horticulture Officer, Ribhai District Nongko, and during my tenure as District Horticulture Officer in the Ribhai District Nongko, I have made physical verification of the land of the petitioner, serial number so-and-so, and 62 a case, and on verification, I have counted the plantation of fruit, etc., standing on the land of the said petitioner, made assessment and issued the assessment certificate to the said petitioner. The assessment was made in the boundaries of the land proposed to be acquired by the opposite party for the purpose of National Highway Shillong bypass prior to taking possession by them. The details of the assessment certificate issued by me to the said petitioner is as under. Exhibit P1 is the assessment certificate issued in respect of petitioners, and then all this assessment certificate he exhibits. Then cross there is no challenge to these certificates. I retired as district horticultural officer in the year 2009. I am a qualified MSc Agri. Exhibit P20 was issued by me. The 19 claimant in this case came to the office and requested me to assess their land, but they haven't made any written request. I agree to the suggestion that the banana plant is the only plant bearing fruit that bears fruit only once in its lifetime, Your Lordship. Save and accept, Your Lordship, there is no challenge to the genuinity of this certificate or the assessment made by him. Now, Your Lordship, how the court has dealt with this evidence. Page 141 of the first paper book, Your Lordship. Paragraph D deals with the structural. Should I read, Lordship?
Yes.
141. For the compensation for damage to the fencing and for the iron gates, claimant number 1 deposed that his 2 plots were having iron fencing and iron gates which were damaged, and he claimed for compensation of rupees so and so for damage of fencing and rupees so and so for the damage to iron gates, and in sport he relied on the valuation certificate by Assistant Engineer Civil Nehu Shillong, White, exhibit the same as exhibit P1 by 3, also proved by his witness number 72, Shri Winter Rose Lindo, who is well conversant with the procedure of assessment of rates of such structures, and he proved the certificate by exhibiting his signature therein as exhibit so and so. Decision. On going to the certificate at exhibit P13, this court found that the assessment by the PW72, a qualified engineer, on which was not disputed by the OP collector, and the same was found to be explicitly assessed with the materials, types and quantity so used for its construction, even with the deduction of depreciation value at the rate of 1% after 1 year from erection at the rate of 9% per annum. But this court found the assessment of the PW72 is not supported by any schedule of such rates. This is the reasoning, Your Lordship, for such assessment done by him in order to prove that his assessment is just, fair and adequate. Though this court believes in such damage of fencing and iron gates, but for fair and just compensation that would be adequate for compensating the loss of claimant would be by accepting 50% of the amount claimed as the actual amount of loss to the claimant. Hence, claimant number 1 is awarded so and so. So, 50% is deducted for no reason. The reasoning which is given that the witness has not explained the that the assessment is not supported by any schedule of rates, Your Lordship. But this is factually incorrect, Your Lordship. I have taken to their evidence. They have stated that I have made the assessment according to the schedule of rates prevailing in 2003 and 2000, prevailing at 2004 or 5, Your Lordship. Now, if we look at the assessment certificate, P13 कौन से पेज पे है? Just your lordship will see the assessment certificate, which is at page 76 of my additional paper book.
How much longer will it take, Mr. Jindal?
Sir, not much, your
We'll
lordship.
continue at 2 o'clock.
Your lordship will see page
You'll close
76.
the arguments today.
Sir?
You'll close the arguments today.
I'll close, sir. I'll
Another
close.
5 more minutes then.
Sir?
5 more minutes you can close.
5 minutes to half an hour.
The other matter there was 1:15. At 2 o'clock you can resume.
2 o'clock, no problem then, because I want to finish it today. And then so
At
that he can
2:15
start.
we'll resume, yes.
Then your lordship will see page 76 of my additional paper book.
76.
Now, basis of assessment in the down. In the assessment, he has categorically stated basis of assessment as per schedule of rates PWD-B building for 2004-5, and for item 2 is as
Where is
per
that?
the last year basis of assessment at page 76. So the finding of the learned trial court that basis of assessment is not explained, therefore deducting 50%.
No basis, and it's not different. It's not the formula used for SOR schedule rates. Basis of assessment is now whether like
Schedule of
they
rates.
go by one by every property that they had this building there, or this crop there, the extent of damage is such, or it's just a ballpark figure, or has it
Your Lordship,
has been put
no.
that assessment was done after
no,
after the structures had been removed.
Yeah.
So that's the only thing. So that is leaves the hazy area. Now the thing is that, notwithstanding that the reference code gave 50%. Now whether court wants to know whether, as per the schedule of value rates, fine, but whether the assessment was done at the time of structural standing before demolition.
No, your lordship, had it been put to him, he would have explained.
No, we can't go under lacuna and evidence. We have to look from a reasonable, perspective. Now, because if the finding of reference code was that this assessment has not, the basis of making assessment has not been given in the examiner in chief, that means that schedule of rates no quarrel, but then assessments how much building.
You are saying everything is explained here because he is an expert, your lordship. And expert evidence here, no, the rate per meter, and because I am not engineer, I won't be able to explain this thing. Now the expert has come before the court.
He's not an expert witness. He's brought by you.
Yeah, brought by me. Naturally, he is my witness, and he's
brought by the court.
His expertise is not challenged.
Of course, he won't challenge, but then you cannot say that he's an expert witness in the meaning of expert witness. That's all.
Your lordship.
Of course, they accept that. I mean, his schedule. Yes.
That one side, your lordship.
I'm trying to understand why the reference court said that the basis is not explained. That's all.
Yes, basis is not, and here basis of assessment.
Okay, fine. The buildings and the fencing. What about the trees? Where's the trees assessment?
No, I'm coming to that, your lordship. Petition number 1, no?
Second half then, Mr. Jindal.
Sure.
Second half.
Right.
Yes. If we're going to finish it, I might as well clear the doubts the court has also. Other matters will take after this matter is over in second half.
Your Lordship, if I'm allowed, Your Lordship, I pray for adjournment in item number 29.
Why?
Conducting counsel could not, she has some personal difficulty, Your Lordship, she could not come today.
Who's conducting counsel?
Ms. NG Shilla.
What matters are gone?
Your Lordship, here we were supposed to get instructions. Our instructions are also incomplete, so we'll require some time.
You're for a petition.
I'm for the petition. My lord, this is that matter relating to VRS of employees of the MEDCL.
Forgotten, yes.
The entire compensation has not been paid to them.
Okay, fine. After 1 week.
Yes, Your Lordship, after the week.
We'll take the other matters after. Other matters ready with other matters, then after this matter is finished.
This is item number 35 as well. I am the petitioner there.
35 already adjourned.
Oblige.
I didn't allow adjournment because you're not informed earlier on. Yes.
Oblige.
May I please, Lordship, item number 31.
Why you not adjourn it?
Senior counsel has went to his son's school because
Who's senior counsel?
Mr. S. Sheikh.
Mister, don't make those excuses. You've gone to son's school or gone to father's school.
Because
there's not for the court. You cannot make this kind of excuses.
Because there is urgency urgent meeting, Lordship.
What happened? He's sick.
No, Lordship, urgent meeting.
Don't make those excuses. You can say personal difficulty. Just teach these boys or something, how to make adjournments and all. Another thing I noticed, other thing is that in dress code also, our juniors do not wear sneakers, do not wear jeans, do not wear, that is not part of the Bar Council dress code. You read where it's written, the dress code of, I've noticed like many, they're wearing sneakers and wearing, it's not done. It was our time, we would have had it. Yes.